This Honorable Court of Criminal Appeals is now in session.
Good afternoon. This is the May session for the Court of Criminal Appeals in Nashville. The panel today is Judge Robert Montgomery from Sullivan County, Judge Tim Easter from Williamson County, and I'm Norma McGee-Ogle. I'm from Sevier County. Each side will have 20 minutes to argue your cases. If you would like rebuttal time, please let me know before you begin your arguments. We are ready for the case to be called.
State of Tennessee versus Ariana Major.
Good afternoon, Your Honors. May it please the Court, Colleen Smith on behalf of the state. I would like to request 5 minutes of rebuttal. The trial court in this case erred in granting the defendant's motion to suppress. The defendant was pulled over lawfully, that is not in dispute, nor has she challenged the use of a drug canine to perform a sweep around her car. The basis of her motion to suppress evidence of the heroin and methamphetamine that were found in her vehicle was that the search following the canine sweep was illegal because the canine had not been trained to distinguish between the odors of illegal marijuana and lawful hemp. The trial court noted that the sweep did not constitute a search, but found that whether there was probable cause to search the defendant's vehicle depended on whether the canine and the officer's training and experience with the canine were reliable. The court found that while Finn had trained with Deputy Owens for 3 years and was certified, his alert was unreliable because he wasn't trained to distinguish between the odors of illegal marijuana and legal hemp. I want to quickly dispute the defendant's claim that the trial court found that Finn was unreliable because Deputy Owens lacked knowledge of his training or that Finn had a spotty record. What the court said was that Finn had trained with Deputy Owens for over 3 years, and that he was certified in his 3rd year of training, and that training records had been submitted to the court, but that none of those records included training distinguishing between hemp and marijuana. The court also noted that Finn had received his canine narcotics detection certification in 2019 through the USPCA. The court noted that Finn was trained to detect 4 types of drugs: marijuana, methamphetamine, cocaine, and heroin. And the court noted that Deputy Owen did not know the procedures for training Finn because an outside company had imprinted him on those scents before Deputy Owens took over his training. But I want to make clear, the court did not find Finn to be unreliable on this basis. Rather, the court found that they had trained together for 3 years and the state had provided records to support that finding. The court also noted that they had conducted too many sweeps together to count. The court did not find that Finn had a spotty track record and instead focused on his lack of training to distinguish between hemp and marijuana, and concluding that his alert was unreliable. And I also want to briefly note that contrary to the defendant's claims, Deputy Owens did not force Finn to alert. Rather, he testified that Finn alerted to the presence of narcotics after being given a chance to empty himself and come into focus. The fact that Finn needed to urinate before focusing does not nullify his alert, nor did the trial court make any such factual finding, so this is a non-issue.
Was there evidence, Ms. Smith, at the hearing that canines are trained to detect hemp?
No, there was no evidence that the dogs were trained to detect hemp. The evidence was that Deputy Owens said it's possible that he could alert to hemp, thinking that because it comes from the same plant as marijuana. But no, he'd not been trained to alert to hemp.
And well, is there such training available? Will we see that in the record? Is there training for?
I do not believe
canines?
so.
Okay.
No, Your Honor, I do not believe so. And also I want to point out that the court didn't address the fact that Finn alerted to methamphetamine and heroin, which were 2 of the 4 drugs that it was trained to alert to. The totality of circumstances in this case weighed heavily in favor of probable cause. But I want to move on to the real issue, that the court erred in suppressing the evidence due to the possibility that Finn had alerted to hemp instead of marijuana. In Hughes, our Supreme Court held that the smell of marijuana emanating from a vehicle provides probable cause to search. And while hemp no more than 0.3% THC has been removed from the definition of marijuana, Hughes remains good law. The standard for establishing probable cause does not require absolute certainty that the substance is in fact marijuana.
Was there anything in the record to indicate where the odor of marijuana that the officer says he smelled came from?
I don't believe there's any evidence that there ever was an odor of marijuana. Rather, I'm sorry, that may be that the officer initially smelled that, but no marijuana or hemp was found. Neither were found. What was found was methamphetamine, heroin, and fentanyl. Fentanyl being a non-issue here because the dog wasn't trained on fentanyl, but the dog was trained on heroin and methamphetamine. So in the end, the dog didn't alert to marijuana or hemp. It alerted to those. But because the dog had been trained on 4 substances, there was no way for the officer to know which of those 4 substances he was alerting to. Only that it would be 1 out of 4 illegal substances.
Well, did the officer testify which of the 4 substances he thought the dog had alerted to?
No. The officer testified. I could only know that it was one of those 4 because that's what he'd been trained to alert to.
And what else was found in the vehicle?
There were 3 things found: cocaine, heroin, and I'm sorry, not cocaine. Let me just look at my notes here.
Meth.
Yeah,
heroin,
amphetamine, fentanyl, and heroin. And the dog had been trained to alert to both the heroin and the methamphetamine. Federal law supports the state's position here. In Clark, the U.S. District Court for the Eastern District of Tennessee noted that the possession and use of marijuana is illegal in Tennessee and under federal law, and the court held that the odor of marijuana provides probable cause to search a vehicle regardless of the legality of hemp. This holding makes sense. An officer is not required to possess absolute proof that a crime has been committed in order to establish probable cause to search. Rather, probable cause is more than a mere suspicion, but less than absolute certainty. The strength of the evidence necessary to establish probable cause is significantly less than the strength of evidence necessary to obtain a conviction. Probable cause deals with probabilities. These probabilities are not technical, they are factual and practical considerations. And as the court noted in Clark, the possession and use of marijuana is illegal in Tennessee. The odor of marijuana provides probable cause to search, regardless of the possibility that it could come from hemp. The United States District Court for the Eastern District, Tennessee, specifically held in Vaughn that the defendant's contention that the smell could have come from hemp doesn't change, that it also could have come from marijuana. And the officer's detection of the smell of marijuana meant that there was a fair probability that marijuana could be found, which is sufficient to establish probable cause. Here, the court applied the wrong standard in assessing probable cause.
Let me ask you a question. If you're driving down the highway and you get stopped and you have legal hemp, and the officer thinks he smells marijuana, then you're in danger of having your car searched.
This is correct, because all that's required is a fair probability. And if that smells like marijuana, there's a fair probability based on a reasonable person's what they're noticing from the totality of circumstances. But again, Your Honor, that would clearly not be sufficient for any kind of conviction, which is a completely different standard. So if somebody did have legal hemp and it was mistaken for the smell of marijuana, yes, it could lead to a search, but it certainly wouldn't lead to any conviction. And what we're dealing here with is a totality of circumstances, whether there's a fair probability that the smell could come from something illegal, and marijuana is still illegal in the state of Tennessee.
But no marijuana was found.
No marijuana was found. Methamphetamine and heroin and fentanyl were found. So
at the hearing, how did we get off on marijuana and hemp in the first place?
That was the basis of the defendant's motion to suppress. I have the same question as Your Honor, because the way I look at it, when that's not even what was found were 3 substances, 2 of which the dog was trained to alert to. I think that even further supports the state's position that looking at the totality of circumstances, there was certainly a fair probability that criminal activity was afoot, providing probable cause to search. So I think your point is well taken.
Well, I'll ask Mr. Gregory Smith about that here.
Yes, I'm sure he has a very different position. The Eastern District Court
Was
of
it just a case where the officer stops the defendant and then just for no reason at all asks the defendant, do you mind if I do a canine sniff? I can't get in my mind what the facts are that led to all this.
And I feel terrible that I'm forgetting the initial reason why they brought in the dog. But I can tell Your Honor that the defendant did not challenge the use of the canine sweep, and a canine sweep is not a search, so you don't have to have probable cause to do a sweep in the first place.
He was convicted or charged with criminal impersonation, driving on a revoked license, and then possession of all these different types of drugs. So, was this a search incident to arrest, or
no?
Mr. Smith will be able to answer that.
She was pulled over for a traffic violation, so she's not challenged that why she was pulled over. She acknowledged that she was pulled over lawfully, and she also didn't challenge the use of the canine sweep in the first place. And the trial court also found there was no issue with bringing in the canine, which doesn't constitute a search. The officer was allowed to do that. It was then when the dog alerted that probable cause arose to believe that there were drugs in the vehicle.
What was the basis of her motion to suppress if she's not challenging me?
But the court found that the dog could have been alerting to the smell of hemp.
Okay.
The Eastern District Court of North Carolina has similarly ruled that the smell of marijuana alone supports a determination of probable cause despite hemp being legal. And the court explained that only the probability, not a prima facie showing of criminal activity, is the standard for probable cause. The defendant cites Cruz, which is a Massachusetts case, to support her argument that the smell of marijuana cannot reasonably provide suspicion of criminal activity to support probable cause to search. But that case addressed whether the smell of marijuana provided probable cause after the decriminalization of small amounts of marijuana, which obviously hasn't happened in Tennessee. And at any rate, that case is unpersuasive, and other jurisdictions have specifically declined to follow suit, which I've noted in my reply brief. I provided a fairly lengthy citation to Rice out of Illinois that goes into detail about the majority of jurisdictions reaching the very opposite conclusion of Cruz. The basic premise being that the smell of marijuana is still indicative of criminal activity to provide probable cause to search, even where states have decriminalized small amounts of marijuana. And similar to the federal cases out of Tennessee that I've discussed, where the smell of marijuana provides probable cause to search, regardless of the possibility that the smell could theoretically come from legal hemp, there is probable cause. The court here erred in suppressing the evidence. And if there are no further questions, the state respectfully asks that this court reverse. And I'll reserve my remaining time for rebuttal. Thank you.
Mr. Smith, I hope you can enlighten us.
Hello, Your Honor. I'm Greg Smith, Montgomery County Bar. First of all, it's refreshing to be on the side where all the presumptions fall on my side of argument this time. And so the view from here is very exciting. A couple of those views, respectfully, the state, just like the defense does when I'm making the argument, overlook determinations and presumptions that go with this case, such as witness credibility, determinations of reliability, viewing the witnesses, and applying the facts that are found.
Did the trial court find the dog was not reliable?
In my opinion, yes, ma'am. If Her Honor looks at volume 1, page 23, which is page 2 of the court's order, at point 4, the court finds Finn's the dog. Finn has alerted sometimes, and sometimes he has found nothing. No specific information on Finn's track record was provided. Then, if you go to the second section of it, which is on page 24, It says, involving canine sweeps, the finding of probable cause turns on the reliability of the canine with regard to the dog's training and track record, along with the officer's training experience and the canine, quoting England. Going on to page 25, it says, the court said, Deputy Owens testified Finn had no training on the distinction between illegal marijuana and legal hemp and would not be able to know the difference. Based upon the evidence presented in the canine training and track record in this matter, the court does not find reliability in the canine to support probable cause. We take the position that yes, the court very specifically addressed that issue, but going over to the officer's question, addressing the spotty record and whether or not, and I affectionately have referred to this argument as Mysterious Moochie's Machiavellian mulligan. And here's why. Volume 2, page 7, lines 18 to 20, Deputy Owens testifying, I tried to run my dog on it. First sentence. I tried. He did attempt to do a sweep and it didn't work. I had to empty him because he, talking about Finn, was not focusing. You don't have to refocus if you haven't focused to begin with. There was an attempt. The dog had to step away because it wasn't finding anything. No, I am not asserting that the deputy demanded the dog to find anything. I'm not asserting that there was some sort of trick command where the dog would lie. What I am saying is when I tried to run my dog on it and I had to empty him because he was not focusing, they did attempt to do the sweep. Now, in response to Judge Ogle's question, how did this mess get started? Traffic stop. At the traffic stop, the officer asked, can I search your purse? Miss Major said, sure. Didn't find anything in the purse. Then he said, well, can I search your car? She said, no. At that point, they went and got the dog. There was no smell of marijuana. Other than her saying no when the question, can I search your car? Nothing else was there to generate the dog coming by. When the dog did come by the second time and focused, the court making a finding of fact that if you're going to explain, and using the bloodhound cases from the 40s and 50s that I've cited in my brief, the Supreme Court has said you can't cross-examine the dog. That's not the issue. The issue is the reliability of the person handling the dog and the application of what the dog's training is to the facts at hand. There again, that's a credibility determination. That's a sufficiency determination. And as the standard of review is different on these sort of cases, there again, I usually argue General Smith's side on most of my cases.
Well, Mr. Smith, I'm still a little confused of how marijuana and hemp got involved in this in the first place. Was there ever any testimony that we were searching for marijuana or we smelled marijuana from the officer? I mean, I'm looking at your motion to suppress, and it looks to me like that's the first time marijuana is ever mentioned in this whole case is in your motion.
Your Honor, that's where we get to the Machiavellian part of this mulligan. The reason that the dog was brought in was because she said you can't search the car. The dog searches. Deputy Owens testified, I have no idea what the dog would have alerted on, but the dog alerted to something.
Mm-hmm.
And then with that, the question, I believe it was Judge Ogle that asked this, and I think you did a follow-up question about, can you tell the difference between hemp and marijuana? Well, Exhibit 2 to the record answers that question.
The judge asked that question?
Yes, sir.
Well, had anybody at that point mentioned marijuana other than your motion?
At the initial, no. But if His Honor looks at, and I've got it a footnote on page 23 of my brief, This is an exchange between Mr. Chase Smith, who is on the line with us. He did the trial counsel, and Judge Ayers. The state has argued that this was just totally out of left field. There was no questions to this effect. That's incorrect. Judge Ayers specifically said, did he, Owens, not say the dog Finn was trained for meth, cocaine, and he didn't know what Finn alerted to because it alerted to one of the drugs. Mr. Smith said that's correct, but Finn could not distinguish which one was alerted. The point here is that on probable cause and the factual findings of the trial court, that on the totality of the circumstances, probable cause has not been met. The court found that, yes, you could alert to 4 illegal substances, 1 legal substance, but you have no idea what substance is being alerted to. That's where you get to the Machiavellian, the ends justify the means, is basically what the state's arguing. As long as we find something, it doesn't matter how we got there. The U.S. Supreme Court.
Why did you or Mr. Smith, the other Mr. Smith, include in your motion the defendant would submit that the search of her vehicle was completed after the sweep of her vehicle by a canine, which is no longer valid, as the canine can't distinguish between the smell of hemp from marijuana. Thus, a positive identification in the vehicle could be for a substance that is completely legal. So,
yes, sir. The reason
there's no evidence in this record, is there, of either hemp or marijuana being in the vehicle?
No, sir. There is testimony about what's called transfer smells, to where if somebody in the area of the car even had smoked a joint, that either the clothing could be smelled, the car could be smelled, or there could have been somebody that threw something out in the grass. But the second part of that is the hemp versus the marijuana itself. Hemp and marijuana got basically separated by the statute in 2019. The testimony by Deputy Owens was Finn and he were both trained in 2017 before there was ever a distinction. The problem is, with the distinction, you've got to be able to winnow that out. Now, if the training comes, and what may happen in the future is they stop training dogs to smell for marijuana and only do the other substances. That's one way to answer the question.
So hemp versus marijuana has absolutely nothing to do with this specific case?
No, ma'am. Respectfully, I disagree with that. There was no hemp or marijuana found in this particular case, but the dog alerts, and the dog alerts exactly the same way no matter which substance the dog smells. And then when asked on Moochie, the person that trained the dog, is there any way to tell which one he's distinguishing on? And I have to commend the officer. He was very upright, saying, I don't know how his training went. I don't know what the dog does to find these marijuana versus cocaine versus any other substance. All I know is if it's supposed to alert, it alerts to something that it smelled. So yes, the marijuana comes into that effect, because if you're trying to get probable cause and you have 4 options, and of those 4 options, one of the options now has a branch that is totally legal, you're looking at a potential of the dog potentially smelling transfer marijuana or transfer hemp on somebody's clothing, alerting, and then in the trunk of a car or wherever, suddenly they find something that is illegal. It would be the same as if going to my house, knocking on the door, saying, we are looking for your dog, and the dog's not to be found, and then they see it walking behind, and then they go out to the backyard and they find a cat.
So if I agree with you, then there can't be any of these dog sniffs until we know that they can distinguish between marijuana and hemp.
Or that they can distinguish between which substance they're smelling, so that if they're smelling heroin, using a hunter's example, a pointer may very well point if they see a duck, but its tail may come up if they see a goose. There's ways to train to where the dog could do a different action for a different smell. And that would be one way to address it. But as long as everything's lumped into one category, Congressman told President Cleveland years ago, what's the Constitution amongst friends, when Cleveland was wanting to veto a bill because he thought it was unconstitutional. The U.S. Constitution, the Tennessee Constitution, is designed to be anti-majoritarian. It's to protect us not only from those that are wanting to hurt, but from the government itself overstepping its powers. And
well, I understand what you're saying, Mr. Smith, in response to Judge Ogle's question. This whole hemp versus marijuana argument really is sort of a red herring here. If in the past a dog has run around a vehicle and indicated, and the search is done and cocaine is found, wouldn't you have the same argument to say, how do we know he thought he smelled marijuana?
Your Honor, and that's where the problem comes in. If you have to guess at the answer, you don't have probable cause. But that's exactly what the Ohio court in King addressed. The fact
that we've never held that in Tennessee when it comes to canines, have we? That we have to know which of the drugs the dog is trained to indicate on. We've never had to say, and in this particular case, he obviously indicated on heroin.
And Your Honor, you're respectfully absolutely correct. But also until 2019, we never had some version of marijuana, hemp, legal. We never had to worry about distinguishing. The legislature.
I agree, and I think I understand your argument on that. And I would think you would be in a stronger position if we had marijuana in this case, but no marijuana was found. No marijuana, no hemp.
And the court found that the initial stop, and that's where you get back to the King case. At the point in time, first of all, when the dog tried and didn't find anything and they had to purge it and let it start over, under the Ohio Court of Appeals decision in King, probable cause should have stopped completely at that point, at the point in time that the dog didn't indicate. But also, the only indication, the only basis for going into that car was eventually the dog indicated, but they didn't know what it indicated on. And then you look, the only reason the dog came in was because after saying, can I search your purse? And they said, sure. Can I search your car? No.
Well, I'm sitting here wondering why that wasn't argued.
I was not the trial attorney on that. And I'm sure that if it comes up again, it probably will be. But what we do have, which is unusual in this circumstance, you've got the mulligan. Just like in golf, if you get to start over, just pick up a new ball and start over, you do your mulligan. Well, if you look at
the dog going to relieve himself was the mulligan?
Yes, sir. The fact that they tried to do a sweep and nothing came about it, and then they went to let the dog focus.
Is there a video of this?
No, ma'am. We do have testimony of the deputy that I've already referenced where he specifically said, I tried, the dog wasn't focusing, I had him purge, and then focused again. If you look at the PGA Professional Golf Tour rules, although I'm bad enough at golf that I do mulligans more than I ever should, if I'm going to follow the actual rules, mulligans don't exist. And if they don't exist for golf, they sure shouldn't exist for the U.S. and Tennessee Constitution. That's why we have Mysterious Moochie, who never testified, but all of the training, all the answers. And Owens was very honest about it. I don't know the answer. Mysterious Moochie does. And then the Machiavellian, as long as we get something in the end, it doesn't matter how we got there, we'll take a mulligan. That's not how the Constitution runs. I'll be happy to address any other questions the court may have. We believe that the court's factual findings and application of law not only were credible, justified, and correct, they should be affirmed. Thank you.
Thank you. General Smith?
Yes, I just have 4 quick points I'd like to make. First, the court found that the canine sweep of the legally detained car was fine. Nobody challenged that. The use of a sweep in the first place just is not an issue. The court found that the dog was unreliable because of its inability to distinguish between the smells of hemp and marijuana. That's why we're here today. The court said, in the case at hand, Canine Finn has trained with Deputy Owens for over 3 years and was certified in his 3rd year of training. Their training records were submitted to the court in this matter. None of the training records included the distinction between hemp and marijuana. That's on page 24 of volume 1. This finding is based on an erroneous standard. Probable cause doesn't require certainty that a dog was alerting to marijuana and not hemp. It really doesn't matter which substance the dog was alerting to. He was trained on 4. It never mattered which of those 4 substances he alerted to. I think Judge Easter accurately described this as a red herring.
It would matter if the trial court found the dog was unreliable, wouldn't it?
If the court had found the dog was unreliable, I don't think we'd be here today on different bases, but that's not what the court found here. What the court was troubled by was what was raised in the defendant's motion to suppress, which was that the dog was not trained to distinguish between hemp and marijuana. That is why we are here today. That issue just really was erroneously decided. Probable cause deals with fair probabilities. They didn't need to be certain that it would, if it had been marijuana, which it ended up not even being marijuana, but had it been marijuana, the police officer didn't have to be absolutely certain that it was marijuana and not hemp in order to search. I mean, that would be obviously to get a conviction. Of course, you need to be sure of that, but that's not what we're dealing with. What we're dealing with is probable cause to search. I also want to point that there was no second sweep by the dog. I want to make that clear. He just needed to empty himself before he focused, and then he did the sweep. And while there's no video of that, I believe that the defendant is making an issue out of this based on Deputy Owens' testimony that I couldn't run him because he wasn't focused. I had to let him empty. Once he emptied, he focused. Then I ran him and he alerted. So there was no second sweep at issue here. I really want to be clear about that. And then finally, looking at the totality of circumstances, there was a fair probability that the defendant possessed any one of the 4 drugs that Finn was trained to alert to. It doesn't matter that one of those smells might have come from a legal source. We're looking at the totality of circumstances here, and the totality of circumstances showed the dog smelled something illegal that it had been trained to alert to, and that's precisely what was found. So for those reasons, unless there are further questions, the state respectfully asks that this court reverse. Thank you.
Well, Judge Ogle, I just got to say I'm bothered now because I take a lot of mulligans, and every time now going forward that I take a mulligan, I'll not only be beating myself up because I have to take a mulligan, but I'll be worried that I'm violating the Constitution. So that's got me worried going forward. Thank you, Mr. Smith, for that. I needed that.
That means you think about the Constitution, Judge.
Okay.
Thank you, counsel. Those were very interesting arguments, and we will see what the record says.
Thank you. Good afternoon, Your Honors.
That concludes the arguments for this case.
This honorable court stands adjourned.